Welcome to the best part of the day. That's when I get to speak about elder law issues with you. Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I'd like to speak to you about a question that was presented to me during a question and answer session after a presentation. Today I spoke at the Queens County Bar Association, and I addressed a group of lawyers. And I spoke about issues related to elder law, powers of attorney, healthcare proxies, revocable and irrevocable trusts. It was really a summary course about all things because of the breadth and really how voluminous the subject of elder law can be. During the question and answer session, I fielded a question that was about a piece of property going into a trust, and what happens when that property is sold. Does upon the death of the grantor of the trust, does the beneficiary have to pay capital gains? So to explain my answer in this question, we have to first know that when you buy a property and then you ultimately sell it, whatever the gain is, the homeowner is subject to paying capital gains on that gain. So just for a simple example, if a person buys a house at $100,000 and ultimately sells it for $1.1 million, there's a $1 million gain. Now, according to tax law and your CPA, there are probably and definitely things that you could deduct. But for the purpose of this question, in my response, let's just take it as a $1 million gain. So the owner would have to pay tax on $1 million, capital gains on $1 million. However, if a beneficiary should inherit that property upon the death of the homeowner and they sold it for the same $1.1 million, there would be no capital gain because they would acquire the property at a stepped up basis. The basis in my example was the $100,000 that the house was purchased at. And again, in my example, the beneficiary inherited the home at $1.1 million. That's the new basis. So if the recipient, the beneficiary of that property, received the property at a new tax basis of $1.1 million and sold it for $1.1 million, there would be no gain, no capital gain. Now, that's why adult parents are really cautioned or advised to really think critically about whether or not they want to give a property to their children, because then you forego that stepped up basis benefit that a beneficiary is entitled to. Within a trust, and trusts, at least the trust that I'm discussing, are taxed as a grantor trust. Right? The IRS views that grantor trust as if the homeowner still owned it for tax purposes. Therefore, even if a property is in a trust, the beneficiary gains the stepped up basis. So you don't lose that tax advantage by putting a property into a trust. If you have a question about this situation or your own unique situation, please reach out to me. Go to Call Frank Bruno and set an appointment. Thank you very much. It doesn't always shut off.